Ready to proceed today on the jury trial?
I'm always ready to defend myself, but I still do not consent. I still do not consent to these trials. These are done on fraud for the tickets were what initiated the stop. And now you're trying to get me on a crime that hasn't even been, we haven't dealt with the initial problem here. So
Okay.
until that's dealt with, how do we know if I committed a crime?
All right, well, one, I'm not trying to get you on anything that's not, stop, I'm not finished. Mr. Renfro, you stopped speaking and then I started speaking, and to be honest with you, it doesn't really matter. When I start speaking, everybody else stops. That's how court works. I've already warned you of that multiple times, so don't test me today.
This right here is a classic case of sovereign citizen energy. The defendant believes that saying, "I do not consent," somehow makes the entire legal system disappear. But watch how quickly the judge shuts that down. She doesn't yell, she doesn't threaten. She simply lays down the hierarchy. When she speaks, court listens.
To question the officers and to have those questions answered that you have about why you were stopped and et cetera, et cetera. That's why we have the trial, and that's why we're having the trial. I am well aware that you do not consent to these proceedings. I am well aware that you don't think the legal process in and of itself is legitimate, but the simple fact is that it is, and you are supposed to be here and we are moving.
What I love here is how she separates emotion from law. He thinks this is a personal attack. She reminds him it's a process. Whether he consents or not is irrelevant. The court has jurisdiction, and that's how legal reality works. Not based on feelings, but statutes.
Already ruled that this court has jurisdiction. That's not an issue that gets brought up in front of the jury.
I have a right to.
Don't. You can object to evidentiary hearings or evidentiary hearing issues. You cannot object to jurisdiction in front of a jury. If you do it, I'm going to excuse the jury, and I'm going to hold you in contempt for not following the rules of court. These are not my rules. They are the rules of the courts of Michigan.
This is crucial. Jurisdiction challenges are a common sovereign citizen move, but legally, once a judge rules on jurisdiction, that's it. You don't get to keep re-arguing it. And she warns him, try that in front of a jury, and you'll be held in contempt.
I say vacate, you say dismiss. Vacate these matters immediately.
Done? One, I've already said that I'm not going to vacate, and dismiss is the right word. I already said that. Two, I've already said that jurisdiction is appropriate. We have subject matter jurisdiction in this matter. We also have personal jurisdiction. Subject matter jurisdiction is because you're in a criminal court in the state of Michigan, and that is what we are dealing with. In fact, it's a misdemeanor, so you're in the right criminal court being district court, so we have subject matter jurisdiction. We have personal jurisdiction over you because it alleges that this matter happened in Burton, and Burton is in the jurisdiction of the 67th District Court. So we have both personal and subject matter jurisdiction. Those issues are laid to rest. If you want to bring them up again, you can bring them up on appeal. You will not bring them up again in this hearing because we are getting ready to start a jury trial.
Here comes the big demand: vacate these matters. He thinks using legal buzzwords like fruit of the poisonous tree will get the case dismissed. The judge responds like a brick wall. Calm. Factual. Unmoved. She establishes subject matter jurisdiction and personal jurisdiction clearly. This is a great educational moment for viewers who don't understand how court authority works.
It's inaccurate. You didn't answer my question. My question was, do you want to speak to an attorney before you move forward?
I'm a competent man.
It's a yes or no?
Lawfully competent man, no.
No. The answer is no. All right, I've asked you that question many a times now. I don't feel like I need to ask it to you anymore. You've established very clearly that you're going to represent yourself in this matter for better or worse.
He keeps asking him for a yes or a no. He tries to dance around it, saying, "I'm a competent man." Translation: I don't want to commit to an answer. She forces him to. That's how judges deal with evasive defendants: precision.
We have no exhibits that we're planning to introduce. We're just going to have the testimony of the officer and Mr. Renfro if he chooses.
Okay. Are you trying to say something?
Is the warrant in here? I don't see the warrant. Or the,
This is the second time you've been given those documents. Do you have the warrant from last time, or the other time
I've
that
asked
someone
this
gave you that?
court numerous of times for the discovery. I have to have it to fight in the trial. I have to have the exhibits to be able to see what's going on or the moves that were made to get me in this position. So that
Answer the
warrant,
question, Mr. Renfro. The question.
This part is unintentionally hilarious. He claims he never received discovery, but the judge reminds him he previously refused to accept it. You can't demand fairness and then refuse the very thing that gives you fairness.
There is no. So here's what I'm going to do, unless there's an objection. I am going to provide the statements for probable cause as well as warrant and complaint copy out of the file. So Mr. Renfro has that. He doesn't have any complaints about not having it. Mr. Our Attorney Stolman, do you have any objection to that?
No.
Okay, all right. So we'll make a copy of that, Mr. Renfro, and I, quite frankly, am pretty confident that this has already been given to you, but we'll make you another copy so that you have it right now. I can copy that.
Despite all the arguing, she still gives him what he asks for. That's the difference between justice and emotion. She may be firm, but she's also fair.
Okay, all right, we will pause on this matter and we will come back in not too long and we'll get started on that jury trial. Thank you, everybody.
Thank you.
This case hasn't even started yet, and the tension is already through the roof. If this is how pre-trial goes, imagine what the jury is about to witness.
Ask it to you anymore. You've established very clearly that you're going to represent yourself in this matter for better or worse. Attorney Stolman, do you have anything that you would like to say in regards to any of the issues that Mr. Renfro has brought up?
Judge, I know he has not made a demand for discovery or request for discovery. I'll give him another copy of the police report, which is the only thing he's asked my office for. I'll have another copy. I believe he has made a FOIA request to the city regarding documents. I don't know whether or not that request has been granted, but I don't believe the FOIA request was all relevant to this case. I believe it was for more documents.
And I believe, Mr. Renfro, you've stated that on the record previously, that the body cams or whatever those were that you FOIA'd them. The prosecutor's office is required to turn over to you all of the evidence that they have and all the evidence that they plan to use, and they have done that. We've had discussions about discovery numerous times. We're not going to delay the trial any longer. So we're gonna have this trial today. Okay.
We have no exhibits that we're planning to introduce. We're just gonna have the testimony of the officer and Mr. Renfro if he chooses.
Okay. Are you trying to say something?
is the warrant in here? I don't see the warrant. Or the,
This is the second time you've been given those documents. Do you have the warrant from last time, or the other time
I've
that
asked
someone
this
gave you that?
court numerous of times for the discovery. I have to have it to fight in the trial. I have to have the exhibits to be able to see what's going on or the moves that were made.